Thank you so much for having me. That have to do with the Section 37 bonusing. So as you're probably aware, the general prohibition against bonusing comes from the Municipal Act, Section 106, and that section basically says that the municipality shall not assist a commercial or business enterprise through the granting of bonuses. And it does set out some of what it considers bonusing in subsection 2, you'll see there on the screen, but generally it is providing assistance to those businesses or enterprises. On the other hand, what is permitted in Section 37, which we've been talking about at length this morning, is more of an exchange where the increase in height or density is being offered in exchange for some other matter, such as facility services that we've discussed this morning. So unlike sort of a traditional bonus where just money or an exemption from paying fees or something is given, this is actually getting something in return for a benefit. Now, what the requirements of the legislation say, and we've discussed this morning, is that there needs to be policies set out in the OP, and my understanding is we have some basic policies, but further work needs to be done, and certainly, and as I'll discuss through this, I do think setting up procedures and mechanisms for implementing the use of bonusing within the municipality is appropriate. And what exists today in the Planning Act is a permission that we can do it is pending proclamation. So this bill actually adds another set of sections. So it doesn't change what was on the previous screen. It doesn't change this. What it does is actually add sections. So one of those things was that the municipality be required to keep a special account that sets out all the monies that are received for Section 37 benefits. And it talks about what can that money be used for in the interim, so we can use it for investments just like other monies under the Municipal Act. But this now will require the treasurer to keep a statement of that account. And for each year, make that available. You'll see that at subsection 10 to the public, and upon the request of the minister, we'd be providing that statement there. Subsection 8 does set out all of the statements that the treasurer will be required to put in that. There was quite a bit of discussion through the, while the bill was pending about why this was necessary, and it was in part to provide some transparency to the process. There was, correctly or incorrectly, some concern from the development industry that monies that were being received by municipalities for Section 37 benefits were not necessarily being used in the way that they were contemplated to be used for. So this, I think, is giving the public a little bit more understanding about what is being received and how it is being used from year to year. Just before I move on, so in terms of the process, typically, as I said, this has received royal assent. These will not come into force until they are proclaimed by the Lieutenant Governor. That, as a matter of tradition, legislative tradition, is usually July 1st or January 1st. So it could be as soon as this July, it could be in the future, at the beginning of 2017. So in terms of these matters going to the board has given some sort of key highlights or has given comments through various decisions that give us the key. In essence, and you've heard from the speakers this morning, there needs to be protocols setting out how we go about calculating what is going to be required as part of the Section 37, whether that be the matters or services or cash for that purpose. The board has been very clear that they don't like if that is applied arbitrarily. So particularly between developments or even while looking at a particular development, there needs to be a methodology there. And certainly we heard from the speakers this morning that that is something that other municipalities who are using these on a day-to-day basis are really looking at putting together a robust plan to ensure that it's not an arbitrary decision that is made through a single development's application process. The other comment from the board is that this is not meant to be a tax tool. They have been clear that the Planning Act is not a revenue generating tool for the municipality, but instead, and as was discussed, it is meant to be a connection between the benefit that the municipality is receiving and the increase in height or density that is being provided. So through that process, you have a methodology that provides clarity for council, for the public, for the developer of how that will be determined, what benefits the municipality will be looking for, and demonstrating what the connection is between the benefit that is being received and the actual height or density increase that is being permitted. That stems back from a decision at the outset of the use of this in 2000, and the board had said along the lines of the contributions that whether or not those contributions are authorized must be judged on the beneficial effects of the proposal. So for example, and I think we heard briefly about this, if, say, the increase in density was going to cause there to be not enough daycare in the neighborhood, then perhaps benefits, facilities, or contributions to daycares in the neighborhood to increase that capacity would be appropriate. Or say if an increase in height was going to shadow a park, you could have benefits related to the park's improvement or other facilities in the area so that there is a continued availability of park services for those residents. In terms of what the benefits could be, you saw there's long lists of things that are articulated in various official plans where they are using Section 37 benefits. It's fairly broad. The legislation just refers to facilities, services, or matters, which really could capture anything. The board, again, has wanted to see there be a connection, and that's really what the test is a connection or nexus to what the increase is. But at one point in time, there was an argument about whether even cash could be taken for it, and that's obviously very settled, and Section or Bill 73 even speaks to that and articulating how that process or how those monies should be handled. But even conveyance of land, that has been clearly articulated by the board as being appropriate. That's just a high-level overview of these, the legal issues. I'm happy to answer any questions if you have them.
Yep, thank you. I do have Councillor Collins.
Thank you. The question I have is, it relates to our incentive programs that we have currently. So I had the opportunity to ask our planning staff, of all the developments we have downtown, and we see cranes here for the first time in 30 or 40 years. Lots of activity, we're breaking development records, but there isn't a high-density development in the core that hasn't been constructed with the assistance of the city's incentive programs. And so we're essentially subsidizing, to an extent, those developments that have taken place. So I try to reconcile, and I think you mentioned it here in terms of, go back to your slide, where you talked about the policies related to how we establish them locally, and we need to expand and elaborate on those programs in terms of determining who's eligible. So I'm trying to understand how we allow people to take advantage of our incentive programs, but at the same time, we may be taking something in return for higher densities, and maybe that's a planning question rather than a legal question. How do we reconcile those two issues? We are incentivizing the development of high-density residential in the core, and at the same time, Section 37 may allow someone to come in using those incentive programs, and at the same time return resources to the municipality, allowing for higher densities. Probably, maybe not a legal issue, but it's an issue for me.
Certainly, through you, Madam Chair, the bonusing process is an optional one, and it's often seen in municipalities where the developers have a desire to, build, construct, develop beyond what is already permitted in the zoning, and there may be financial incentives already existing for the developers to want to undertake that process and provide the municipality with benefits in order to obtain that further density or height. often the incentive programs are sort of the opposite side of that coin to incentivize developers to come and just build, in accordance with what already exists today. So in terms of reconciling that, they're often meant for two different purposes, and I'm happy to allow planning to speak to how those would operate together for planning approvals.
Thank you. Jason?
So through the chair, I think that the councillor has hit on an important point, and a point that makes at least the utilization of these tools in the downtown core of Hamilton potentially different than some of the precedents that have been put before you, in that we've heard this morning about Vaughan, about Mississauga, Burlington, Toronto. In those situations, the development that's happening there isn't happening under the auspices of some of the incentive programs, DC reductions that we have, at least in our downtown core. So I think that is an important point and an important consideration in how this tool might work in Hamilton, in that a lot of the activity we're seeing is in large part thanks to some of those programs that the city has put in place. So what would then layering a bonusing regime on top of that then look like, and how would you, in the councillor's words, reconcile that? I think it's an important unique nuance, I think, in how these tools might get applied, at least in the downtown core of Hamilton.
Thanks for that, Jason. So what's next for us in terms of providing direction in reconciling the two sides of the coin? I think it's, we're different than Toronto and everything happening in the GTA, where they're talking about caps and struggling to control really growth that's occurring unchecked. And here, although we have tremendous numbers as it relates to new development, and we're establishing new records for building department levels of investment, and we're certainly seeing higher densities, we're not experiencing those same pressures that Toronto and others are experiencing. And our projects are only happening in large part because those carrots that we have within the department, and we've all supported those, and they're there for good reason. Somehow, I don't know from a policy perspective how we sort that out, and I don't know what staff is contemplating informally or formally at this point in terms of trying to reconcile the whole issue of incentivizing development versus this whole issue of the bonusing and the reverse payments that then come to the municipality. Can I ask through you to Jason, what are we doing from a policy perspective to deal with that issue?
So through the chair, I'll start, and I'm going to ask Steve to weigh in on sort of where we're at with some of the thinking on bonusing. It has been being sort of developed and thought through originally as part of the tall building guidelines, and making sure that as we're looking at our tall building policies, are we having those policies be, for lack of a better word, bonus ready, and are we looking at them through the lens of potentially applying bonusing related to tall buildings? I'll let Steve speak to that process and where we're at with developing that policy. I think there will be two key questions before this council in terms of how this might work in Hamilton. One is the very important question of just the methodology, the formulas, the policies. As has been said many times this morning, an ad hoc approach is certainly not advised. So how do you actually, who's doing the negotiation, what formulas are applying, all those sorts of things we don't have yet in place. And so a lot of the thinking has been focused on those sorts of questions. The second big question then is where in the city and under what thresholds. So that I don't have any comments to give at this point in terms of where and what thresholds might be suitable in Hamilton, but those really are the two key questions. So with that, I'll turn to Steve to talk about sort of where we're at so far in terms of thinking through what that policy approach might look like in the city.
Thank you.
Steve?
Through you, Madam Chairman, building on Mr. Thorne's comments, one of the challenges is the current policy framework. Often it's very permissive. So within the downtown, for example, you can increase the height without necessarily triggering the need for an official plan amendment, subject to a wind study and a sun shadow study. So you can go from essentially what was originally identified for a low-rise building to a high-rise building without triggering a need for an official plan amendment. So the work on the tall building guidelines is to help inform the policy direction so that we can better provide clarity and direction to people that if there is going to be a proposal involving an increase in height and or density, then would it then trigger the need for an official plan amendment or a zoning amendment, and or would it also then follow up with the opportunities to look at the opportunities for bonusing, and then as we sort of develop that policy framework, rolling it out further across the city. So it's also between looking at some of the market opportunities, the market intelligence, as well as the current official plan policy designations. I think one of the challenges you have is bonusing has to apply. The first test is it has to be good planning. Regardless of whether you use Section 37 or not, the proposal must represent good planning. So if it does represent good planning to, say, have an 8-story building along Main Street, then do you designate it for only 6 and say you go to 8 subject to a bonusing provision, knowing, or do you say that we're just going to allow 8 stories as of right? So these are sort of the discussions and the challenges that we're having, and that's why we were looking for the experiences in other municipalities that are more in a comparable situation, where they want to both promote growth as well as manage growth, and then how would that policy framework evolve? So I think that's going to start evolving into as we start rewriting the downtown secondary plan and looking at other opportunities for updating our official plan policies around this so that we can provide very clear, transparent rules to individuals that when they're looking at acquiring a property, they will know whether or not if they want to increase the height or density, then what would be those sort of bonusing requirements the city would be looking at, and that would be applicable beyond just the downtown area.
Councillor?
Thanks. My last question would be, in that context, again, the Toronto developments are a lot different than what we experience here in Hamilton. Big developments for us are 8, 10, 12, 15 stories. In Toronto, they're talking about 40, 50, 60-story buildings. And they're very common. In fact, I think I read right now, Toronto has 20 plus applications right now for 40 or more story buildings. And so, again, the bonusing that comes with those developments and the applicants who seek higher densities on those projects pale in comparison to what we would experience here, and you use somebody wants to go from a 6 to an 8 or an 8 to a 10. I mean, the Section 37 gets us what in that context?
Thank you. Joanna?
A bike rack?
I think in terms of those heights and that change, I mean, that is sort of some of the experience of Richmond Hill, and you heard some comments about that earlier in terms of the density increases. But in terms of sort of what you get for that, the answer really comes down to what are the protocols in place and what were the things that this council, as opposed to what Toronto or Vaughan or other municipalities are looking for, would expect to see in terms of those increases in height. So it's hard to say what would you get for it until we've gone through that process to determine what would be appropriate to get for it.
Thank you, Councillor. Planning, can we have your opinion on
Through you, Madam Chairman, I would suggest we might want to take a look and say the City of Ottawa model, where they've actually have 2 sort of zones where they do their bonusing. Within their downtown core, they have a different sort of bonusing evaluation as to what that increase in height and density would be, as to other parts of Ottawa, which might be much more suburban. So they sort of will look at it from that lens, that you may have, or even in Toronto, like along Shepherd Avenue, where you have the mid-rise development occurring, you're getting something, you're getting 100% of something, or you might be better off getting 80% of something as opposed to 100% of nothing. So it would just be one more tool that the city could put into its toolkit when negotiating that. It may be community facilities within the building, if you're having the redevelopment. It may be an opportunity for additional open space. It may be public art, or it may be affordable housing, or contribution towards an affordable housing payment within, say, a housing submarket zone. We know that in different areas of the city, we have those 5 or 6 different housing market zones, and there are often various levels of affordability needs within those different zones. So that would be the type of policy regime we could look at. So maybe in the downtown area, we want to encourage certain things. In other areas where we're trying to use, say, less encouragement is required, then in those cases, a bonusing regime may make sense. And that would be something that we would be looking at. We do know that there are different markets within the Hamilton area, and some markets might be able to better absorb these sort of bonusing costs, provided people know going into it, than other areas we're trying to encourage and promote policies and other goals and objectives. So I think that's sort of the lens that we want to look at it on a go-forward basis.
Thank you, Councillor.
For me, it's about tempering expectations in terms of we're a different market than Toronto, and I don't expect, in a perfect world, I mean, I'd love to see those types of developments in terms of the densities, the construction activity, the jobs, everything that comes with it. We haven't seen it yet. It's going to be here at some point in time in the future, but it isn't here now. So the fact that we're in the early stages of developing a policy framework to deal with it ahead of that wave, whenever it does come, I think is it's a good thing. And if staff need direction today, I guess my final question would be, do they need direction today to start working on those issues, those unresolved issues, or is that happening as part of their work plan for 2016 and 17?
You're asking planning staff?
Yep.
Thank you.
Madam Chairman, it's already part of our work plan, so we don't need any specific direction to do any more further investigation on this matter.
Okay, thank you. Councillor Pearson, okay. So Councillor Collins, it's okay. Councillor Collins, can you please take the chair? Through you to Joanna, if you can go back a couple of slides for me, please. One more, there it is. Your last bullet point, there should be a nexus, which I thought was always a card to get me over to USA. Relationship between the height density increase and the benefit. So, to be clear, is it very specific that it has to be used in that immediate area of that particular development?
Generally speaking, that is what the board looks at when they're looking at whether a benefit is something they would approve.
Okay, thank you. And so my idea of a neighborhood and your idea of a neighborhood could be total polar opposites. So who decides the boundary? So I want to come in, I'm going to put up a massive building, but I've now got this agreement with the Section 37. What's the boundary of where this money, especially the cash in lieu, I think that's where my main concern is, because usually facilities are built close and on the property, but it's the cash in lieu that, how do we ensure it stays within that community? What are the boundaries?
The board hasn't looked at it in terms of boundaries. What they've said is so what you're proposing to use that cash for, does that thing, whatever that might be, relate to, is there a nexus to the increase in height or density that was permitted? So in terms of where the effects or the relationship is, that defines the area, and it could differ based on what the matter, the thing, the benefit, the service was that is being granted. And unfortunately, it's very fact specific, so it's hard to give a just general test for that.
Okay, thank you, because I think if the policy is too vague, there can be so many spins on it that before you know it, that the community receives nothing, because it ends up being outside, and it's because you can actually correlate, this is why it would be good for the community, because this community over here. So that's where my concern is. Can we, as a municipality, look at that policy and be a little bit, tighten up the language so that it does, in fact, if Councillor Farr is going to end up having a massive development, that the Section 37 cash in lieu is benefiting that community and that neighborhood and not going somewhere on Mount Hope. I mean, this is where my argument, question.
Certainly that can be considered through the process, and making that clear and transparent is certainly what the board looks for when they're looking at whether a Section 37 benefit is appropriate or not.
Thank you. And it also helps, in my opinion, to when you're doing public consultations, you know, this is what we're going to benefit from this. If this is coming in, we get this. So it really does help the yin and yang. So thank you very much, Joanna, for your questions and your presentation. I'll take the chair back. Thank you, Councillor Collins. Councillor Vanderbeek, sorry, I didn't see your hand up earlier.
Thank you. So, through you, Madam Chair, can you tell me if the City of Toronto has been challenged? So the wording that I have here is, in the specific case of affordable housing as a community benefit, the appropriate geographic relationship is considered to be citywide. The location of affordable housing as a community benefit can be anywhere in the city or is otherwise specified. And so do you know whether that's been challenged as a neighborhood benefit at the OMB?
I'm not aware, no.
Councillor?
Thank you.
Okay. Thank you. And no other questions, Joanna. Thank you very much for your presentation. May I have a motion, please, to approve the presentation? Councillor Conley, Councillor Vanderbeek, all those in favour?